We talked on our first video segment about the history of the Alabama DUI law. This segment, number 2, we're going to discuss what is Alabama's DUI law. And where do you find Alabama's DUI law? You go to the Alabama Code, go to section 325A1921, and there it is. It says that a person shall not drive or be in actual physical control of any vehicle while under the influence of alcohol. And we are talking about alcohol DUIs right now. We'll talk about the other 3 types in just a second. So let's break that down. Driving, that's easy to figure out. Somebody's driving a vehicle. Or in actual physical control. What's that? It was defined years ago by case law in Alabama as having 3 elements, basically. Person has to be in the driver's seat, keys have to be in the ignition, and the car has to be operable. So if those 3 criteria are met, then the person could be convicted of actual physical control and a DUI. They've changed that and and they said, no, you take the totality of the circumstances, and each case falls on its own facts to determine whether or not the person was or was not in actual physical control. Basically, the meaning behind the law is that if a person is intoxicated, has the ability to start the car and drive off, then they're a public safety hazard and subject to being arrested and perhaps convicted of DUI. The next element, driving or being in actual physical control of any vehicle. What is a vehicle? Is a bicycle a vehicle? Is a golf cart a vehicle? Is a motorized wheelchair a vehicle? Is a goat a vehicle? Let's go to the Alabama Code and see how it defines vehicle. And I'm going to read from the Alabama DUI handbook, which is our book. So vehicle, every device upon by which any person or property is or may be transported or drawn upon a highway, except devices moved by human power or used exclusively upon stationary rails or tracks or electric personal assistive mobility devices, provided that for purposes of this title, a bicycle or a ridden animal shall be deemed a vehicle, except those provisions of this title which by their very nature can have no application. So is a goat a vehicle? Yep, if you're riding him. Is a golf cart a vehicle? Yes. Is a bicycle? Yes. So is a personalized wheelchair a vehicle? No. So driving or being in actual physical control of any vehicle, and we've defined vehicle. Under the influence of alcohol, what does that mean? People that wrote the code did not define under the influence of alcohol in the statute itself. It was defined in 1989 by the Alabama Supreme Court in a case that yours truly had the privilege of handling, and we'll talk about how they define that in just a second. But prior to 1989, when judges would charge or tell the jury what the law it was in terms of under the influence of alcohol, they would say this: if you were under the influence of alcohol to any extent, you're under the influence of alcohol. So what is that? That's zero tolerance. That makes it illegal to drink and drive, because whatever little amount you drink, it's going to influence you in some way, make your liver itch, whatever. So that didn't make sense, made it zero tolerance, made it illegal to drink and drive, in my opinion. So I fought for 4 years, and the Alabama Supreme Court adopted my definition, which is, and it still stands today, although the last 2 times in the legislature has added bills to change the definition. Under the influence means drinking of alcohol, means drinking to the point that the alcohol makes you an unsafe driver due to the amount consumed. Okay? So, when we talk about alcohol, there's two ways to be charged with DUI. One is what we just talked about, driving under the influence of alcohol, which is defined as drinking to the point that the alcohol makes you an unsafe driver. The other way is what we call a U-ball case, or unlawful blood alcohol level case. Sometimes they're called a per se case. Sometimes they're called an A1 case in the state of Alabama, because that's the subsection of the code and of the DUI section that this is found. It makes it illegal to drive with a blood alcohol content of 0.08% or greater. That is typically measured, we are a breath test state, and it's typically measured by a breath alcohol device. We'll talk about, there are two types of breath alcohol devices, one at roadside, one at the station. The one at roadside you don't have to take, no written penalty for it. It might be your ticket to jail. The one at the station, if you refuse it, then you're privileged to operate a motor vehicle would be subject to being suspended. All right, so the next way to be charged with DUI is driving under the influence of a controlled substance. We've got the same elements, driving or being in actual physical control of a controlled substance. It's in the Alabama Code, a list of schedules 1, 2, 3, 4, and 5 of what is a controlled substance. A prescription for it is not a defense, but if you're under the influence of a controlled substance to a degree that it renders you incapable of safely driving, then you are subject to being convicted of DUI, controlled substance. It's a little bit of a higher standard in my view, being under the influence to a degree that it renders you incapable of safely driving. The fourth way to be charged with DUI is under the combined influence of alcohol and a controlled substance. Means what it says: if you have a controlled substance and alcohol on board, and they can prove that a combination rendered you incapable of safely driving, then you're subject to being convicted under that code section. The fifth way of being charged and or possibly convicted is what I call the driving under the influence of shrimp provision. It means it's driving under the influence of any substance which renders you incapable of safely operating the vehicle. So it could be shrimp, it could be NyQuil, it could be paint hacking, and any substance that's not a controlled substance and not alcohol. Our goal is to minimize the overall impact to you, your family, and your job. Timing can be important in DUI cases, so call us now for a case evaluation.